I am, my lord, and I think I will say a few words by way of introduction, if I may.
You can take it. I've read most of the material, not all of it, but most of it, and particularly the stuff relevant to this hearing.
I'm grateful to Your Honour for that, and if Your Honour has had a chance to look at the skeleton, Your Honour will have got quite a good sense of the background to this. I should start by saying that of course this is the pre-trial review of the matter, and as Your Honour will have seen, the trial is listed for 5 days, starting on Monday the 31st of July, running through to Friday the 4th of August. And to start with a good piece of news, Your Honour will have seen that both parties have confirmed that they will be ready for trial on those dates.
Yes.
So that's the positive. In terms of housekeeping, Your Honour should have the bundle, and I apologise, it's a little bit on the fat side, but it has what we need for today. And Your Honour will also have my skeleton, which I hope you've had a chance to look at. And Your Honour, I hope, has received the very helpful email from Mr. Akiki, who's one of Mr. Lovett's team, which helps us steer through this, I hope, pretty quickly. Your Honour, in his pre-reading, will have got the gist of the case, which is that this is about the sale of 4 schools in Kuwait. All the parties are Kuwaiti. There is a fairly sophisticated SPA which is in the bundle. I don't need to trouble Your Honour with that today, but what Your Honour needs to know is that the contract is governed by Kuwaiti law, but is expressly subject to the exclusive jurisdiction of Your Honour's court in the DIFC. The debate is in relation to a sum of 4.5 million Kuwaiti dinar. There are, broadly speaking, about $3 to each Kuwaiti dinar. So 4.5 Kuwaiti dinar is about $15 million in round terms. That's the number which is broadly in dispute. My clients, the claimants, say that that sum should have been paid. Mr. Lovett's clients say they don't have to pay it because there are a series of set-offs which they can exercise against that sum. And as I flagged in the skeleton, the likely battleground in the trial that Your Honour has to come to is what are those set-offs, what shape do they take, what is their value, are they sustainable? But that is not for today. Your Honour will have seen, I hope, that the parties have each served 2 factual witness statements from 2 factual witnesses per side, so that the claimants call evidence from a Mr. Mahmoud Saad Rashad, who is the CFO of my clients. And they also have served evidence from a Dr. Shanta James, who is the former principal of one of the schools that was sold. And on the defendant's side, there are likewise 2 factual witnesses, Mr. K.O. Matthews and Mr. Al-Falah. But Your Honour is going to hear at trial from 4 factual witnesses. In a similar way, he's going to hear from 4 expert witnesses, each side having called an expert witness on quantum and an expert witness on Kuwaiti law. Again,
are we going to treat Kuwaiti law as a matter of evidence of fact, or are we going to allow the lawyers simply to present their cases?
The way the parties have proceeded so far is to do it in a slightly old school way and treat it as a piece of evidence of fact. So Your Honour will have seen in the articles there are extensive reports. I think, and Mr. Lovett may disagree with me, but I think the Kuwaiti law is coming together quite nicely. So that I don't think Your Honour is going to have too much to decide on Kuwaiti law, but there will be some points of difference between us. But I'm thinking we're going to tender both of our experts, and Your Honour will decide it as a matter of fact.
Right.
And I'm in Your Honour's hands on that, but that's the way the parties have proceeded on that basis.
I think the modern tendency in the IFC courts is to treat it as a matter of submission rather than fact. But I've got no firm view, and I don't want to disrupt preparation that's already taken place. So I'm content to proceed along the agreed lines, if that is the agreed position.
It's certainly my position. I should just look to Mr. Lovett to make sure he
My lord, yes, that is agreed. on our side, there is a Court of Appeal authority, I think, now in the DIFC that it tends towards submission, but Q80 law may be more esoteric than some, I suppose. But we proceeded on the basis that it's a fact to be proven at the hearing. But as Mr. Lyons says, we're fairly close to agreeing most of the points.
Yeah, well, that's helpful. Well, let's proceed on that basis. I'm content with that.
What I was going to tell your Honour next is just what remains outstanding by way of the procedural timetable. So your Honour sees where the parties are and sees what needs to be done. None of this, I think, should trouble your Honour, but I should just flag this, your Honour, by way of transparency. On expert evidence, there has been 2 rounds of evidence on Q80 law. So the Q80 law experts have served their main reports and have each served a supplemental report. The 2 gentlemen who are the Q80 law experts need to meet and need to file a joint report. The date set for that is the 7th of July for the joint report. And from my side, I have no doubt that that will be met. I think that Mr. Lovett is working to the same timetable as well, and that's on Q80 law.
7th July.
7th of July.
Yeah.
So that will have been served in advance of the skeletons, etc., and in advance of the bundle. So everything should be ready to go.
Yeah.
On quantum, each side has served their main quantum report. We have pushed back the date of supplemental reports because your Honour will have seen that, sadly, Mr. Lovett's expert's father passed away, and so there's been a slight hiatus there. Supplemental reports will be served at the end of this week, with a similar timetable for joint reports to follow. So again, the joint quantum report should be in by the 7th of July, again 3 weeks before the trial date. And I think both of us are content that that gives us plenty of time to get our house in order.
Yeah.
In terms of the sorry,
you don't need any directions about this. You're happy to proceed on the agreed basis.
We've proceeded on an agreed basis, and we have troubled the registry with a consent order which has been sealed. It isn't in the bundle, but we're both working to a timetable which the court has approved. So this is really just by way of information for your Honour, to make sure he knows that we're in a good place.
Yeah.
And then the next exciting topic is trial bundles. They are due to be ready by the 17th of July. My team are going to try and get them ready a bit early, and I'll obviously liaise with Mr. Lovett about those. But the question for your Honour is, how would you like the trial bundles? Does your Honour want to do this electronically? Would you like me to have delivered to you some hard copy bundles? I don't really have a sense as to what we're looking at. My best guess, and I will probably be stamped on for saying this, is probably about 5 or 6 Liebreich files. That's my best current guess of what the trial bundle is going to look like.
I think it's not regarded as fashionable nowadays to have paper copies of everything, and I'm content to proceed on the basis of what I've found to be the usual electronic trial bundle.
Very good. Well, we're happy to work to that basis if your order is.
As long as it's properly organised.
Yes.
I mean, it's not going to be the sort of case where we need 3 documents open at the same time. Is that right?
We may end up in a situation where I'm showing the witness their witness statement and a contemporaneous document at the same time. So it may well be that if your Honour works on 2 screens, that might be quite helpful. But
I work on screens, but sometimes it happens that you end up having a document which doesn't fit into the screen, and then you're being asked to compare that with another document, and that creates difficulties. So if it's that sort of case, it may be relevant if there are spreadsheets and stuff.
I mean, we will look at that. I think that there were some spreadsheets in the disclosure. My current thinking is that we're not going to need to trouble ourselves with those, or trouble ourselves for very long with those. And your Honour will please know this isn't a case with plans or scientific diagrams or anything of that sort.
That's fine. Well, let's proceed on the basis of an electronic bundle prepared in conjunction with the registry in the normal way.
Very good.
Thank you.
We will do that. And if as your Honour goes along, your Honour would like something in hard copy, we will of course facilitate that and get that to your Honour. the last point is that skeletons are due 1 week before trial on Monday, the 24th of July, and we will get those to Your Honour at the allotted time in an electronic form.
And are they going to be exchanged, or are they going to be sequential?
We have got, at the moment, we've got simultaneous exchange, and Your Honour would have seen from my skeleton that I was slightly worried that I didn't fully understand Mr. Lovett's case. Yeah. But as I'm going to come to, he very kindly has offered us a position paper, which I think will allow simultaneous exchange of skeletons.
Yep. All right.
Your Honour, turning now just to the business of the PTR, I was going to use Mr. K.S.C.C's email as the agenda, as it were, just so that we can all keep track of what's going on.
Yes, I have a few points of my own I want to raise at some stage, but I'll take it.
You're on to go to identify those first.
You go first, and I'll chip in when necessary.
Your Honour, I'm grateful. What I'm proposing to do is take each topic, say my piece, pause, let Mr. Lovett say his piece, and then move to the next topic, if that suits Your Honour.
Yeah, sure.
Your Honour, position paper. You'll have seen from my skeleton that we have some points of confusion. Mr. Lovett helpfully has agreed to provide us short position paper. I'm grateful to him for that offer. I've only got 2 points of detail, which is that the position paper he agrees to provide really needs to comply with the 3 short requirements I included in the skeleton. At paragraph 58 of the skeleton, which is that he to identify the warranty which he says has been breached. There has been a breach of warranty X, and of course that's because we're in a contractual framework and we all need to know what it is said has been breached. He needs to say how that's been breached. This happened, and he may want to put references in, and he needs to tell us how much he says is the value of that breach. So I'm asking what warranty, how has that breach occurred, or what basis, and to what value. We say self-evident, but I put that marker down because I think that would be helpful to my side and helpful to Your Honour as well. The other thing I would say is this, which is that Mr. Lovett's team say they will try and have it ready by the 7th of July. I say they must have it ready by a fixed date. I'm not going to hold them to the 7th, but I think this is the kind of case where effectively a deadline is required so that everyone knows the timetable they're working to. So I don't want to be awkward, but I do think that when Your Honour comes to make an order on this, there should be a fixed date for delivery of that position paper.
Yes, the only comment I'd add on the three headings is this, that the quantum of the claim under each breach of warranty may, of course, be more difficult to pin down because it will no doubt interact with other quantum for other breaches. But so long as that's understood, then and that has to be articulated in the position paper. But with that qualification, I think it's very useful. What I'd like to know, though, and perhaps Mr. Lovett can help on this when he comes to speak, is the status this document is going to have. Is it going to replace or act as a compendious set of particularized breaches of warranty? Or is it going to be, am I going to be faced at some stage with an argument, oh, well, it may not be in our position paper, but it's clear from other bits of our pleading. It seems to me that if the value of this thing is it pins it all down to one document, and if evidence is then led which isn't reflected in any claim in the document, then I can disregard it. But I'll ask Mr. Lovett what he...
I mean, if that would be easier for you, my lord, then I'm very happy to proceed on that basis. I mean, essentially, it's a particularization of the claim, which ordinarily would have just been part of the pleadings. But if you would prefer that document to be leading the evidence, we're happy with that.
No, I don't so much want it to be leading the evidence, but I don't want there to be uncertainty as to whether something's in or out. which may not be mentioned in a position paper. When one party says, well, therefore I haven't prepared to deal with that point. The other party says, oh, well, it was already in our particularised claim.
Well, I think sorry, my lord. If it's helpful, I think the intention is to where we think we can, and we've already explained it or pleaded it. We'll cross-reference that paper to the pleaded case. But I understand the point, and we will prepare the paper accordingly.
And presumably, you'll confirm this or not as appropriate. Presumably, it's not intended that this allow more claims for different breaches to come in that haven't presently been pleaded. Is that right?
No, it's not intended to be a stalking horse for further breaches.
Right. Okay, well that's very helpful.
Your Honour will have seen that the number of breaches has come down, and I'm very much hoping that the number of breaches will either remain at the current number or will come down further.
Yeah.
Mr. Lovett says that he intends to cross-reference some of his existing pleading. Your Honour will have seen from our skeleton that there appears to be a slight movement in their case in certain areas, and really what the position paper is designed to do is to allow Mr. Lovett to pin his case down to what he now says it is, so that we now know what we're addressing. And I would caution against too much referring back, because he may find himself referring to a piece of history which no longer is borne out by the evidence before the court. So I'm rather generously, I would say, I'm giving him an opportunity to pin his case to the evidence as it currently stands.
Well, I'm not going to tell Mr. Lovett how to plead or replead his case, but I think he has my point that I want something where it can be fairly clear if the evidence strays beyond what is properly an issue, and I'm taking the short position paper, cross-reference or otherwise, to be the definitive version of the defendant case.
That's understood, my lord.
Yeah. The only thing, it's probably too late for me to raise this. I wondered, there's effectively three categories of claim, as I understand it. There's breaches of warranty, which are set off against the, I've forgotten what it's called now, the final payment anyway. Then there's the cost of the guarantee, which is the second heading, and the third one is, no, sorry, the second one, yes, cost of guarantee is the second one, and the third one is the cost of, I've now forgotten, anyway. But on 1 and 3, it seemed to me that effectively what the defendant's case is, they don't really dispute the claimant's case, but they say, yes, you may be entitled to this in principle, but we're entitled to set off claims for breaches of warranty. And in some situations, that would lead to an application on the part of the claimant for the defendants to lead, because it's up to them to make good their case for breach of warranty. I'm not sure whether that applies to the cost of guarantees as well, but it's probably too far down the road in terms of preparation for any such discussion to be had, I imagine.
I mean, it's a thought which had crossed our minds, Your Honour, and you'll see that we slightly dipped our toe in the water, as it were, with the idea that Mr. Lovett might want to serve his skeleton first. I'm content, though, that the evidence can come out in the traditional fashion of the claimants going first and the defendants coming next, and that Your Honour can hear the case in that order if we all know, as a result of the position paper, what Mr. Lovett is going to say. So I don't have a problem in staying with the traditional order if there is real clarity as to what Mr. Lovett's case is.
Well, that's fine. I think the position paper idea probably avoids the danger that sometimes happens as the claimant leads and doesn't quite know what is up against, and it's too late by the time he does to lead his own evidence. So, okay, well, I'll make an order then. What about timing, Mr. Lovett? You say you'll do best endeavours by 7th July. Can you give a more absolute?
I could just, if you give me 1 second, my lord. Yeah, we can commit to the 7th. So if we work to the 7th, we're happy to do that.
Very well. I'll make an order then that the defendants will provide a, what do you want to call it, position paper setting out their case on breach of warranty, and in particular identifying which breaches of which warranties are alleged to have happened, the factual basis for their case on breach of warranty, and their case on quantum in respect of that breach. And they will do that by close of business 7th July 2023.
Well, thank you.
Anything else on that one?
Not for me, Your Honour. The next topic is virtual trial. We understand that the trial is going to be virtual.
Yes.
Your Honour, as I understand it, will be in Scotland. Yeah. Mr. Lovett is habitually in Dubai. I flit between London and Dubai, but for the trial, I intend to be in Dubai just because it's more convenient. And I think that works perfectly well. The consequence of that is the witnesses will be giving their evidence virtually. You've got witnesses from all over. Dr. James, the former school's principal, is based in India. You've got the Kuwaiti law experts who will, I suspect, either be giving evidence from Kuwait or maybe flown to Dubai to give evidence, but they will be giving evidence from the Middle East in one guise or the other.
Yep. That's not uncommon.
Mr. Lovett's quantum expert is based in Dubai. My quantum expert is based in the UK. So there'll be evidence from those sources. The only point Mr. Lovett makes is, can he know what my arrangements are? And I would say, can I know his arrangements? And I was going to suggest, Your Honour, that if that's acceptable to you, we should share our practical arrangements for the giving of virtual evidence. And we should do that a few days before the trial. And I was going to suggest the Wednesday of the week before trial, but I'm in Your Honour's hands as to whether that is a sensible thing to do.
This is rather beyond my pay grade. I'm not a technical person. I've always turned up and the witnesses have had things done to their machinery or not to enable them to be heard. It doesn't always work perfectly. But I'm happy to leave it to you and Mr. Lovett in conjunction with the registry. I think the registry are the important people there to keep them informed of what's going on and make sure everything is tested beforehand. But yes, I'm content that you make what arrangements you think appropriate, as long as they work.
Super.
Well, yes, thank you.
I don't think you need an order for that, do you?
No, we don't. As a consequence of being virtual, I think it follows that the witnesses will be virtual. So we don't need any orders, as I understand it.
The only question that has been brought to my attention in another case, I'm not going to tell you what I think about it. But if you look at, I don't know whether you have the book, the AJIAL Courts Practice.
I do on my iPad.
Schedule B to Part 23, and it was all written, I think, before virtual hearings became the norm. But it's paragraph 4 under the heading video conferencing generally. Says it should not be presumed that all foreign governments are willing to allow their nationals or others within their jurisdiction to be examined before a court in the DIFC by means of video conferencing. If there's any doubt about this, inquiry should be directed to the registry with a view to ensuring, and so on. You were talking about some witnesses from India, some from Kuwait, and some from England, possibly.
Yes.
Have steps been taken to check that the relevant authorities in those various countries don't object to witnesses from their jurisdictions being cross-examined or examined in the DIFC? It's not something I've come across until it was brought to my attention
Yeah.
a little bit ago.
I mean, I think that requirement is copied out of the London guides, where effectively when you fill in the request for video conferencing or something you did before COVID, you had to say, I've taken advice and I'm told by counsel in this state that there is no problem. To be frank with Your Honour, I have not made those inquiries. I think we're pretty comfortable that Mr. Brown, the quantum expert, can give evidence from the UK without any problems. But I mean, what I'm happy to do, and I'm happy to be directed, if Your Honour wants to be directed, to check that for both India and Kuwait, and to confirm in writing to the registry that there are no difficulties. And it may be that Mr. Lovett wants to do the same.
Well, again, I mean, I'm not aware. So it's that that direction is certainly new for me. I guess it's aimed principally at Swiss nationals, possibly, but we will check. We will check the position in Kuwait. But I'm reasonably comfortable, and I think Mr. Lyons and I can take it offline. But we will see to it that that's done.
If you can just have some maybe agreed noting with the registry that that has been done. I don't want to know all the evidence and so on. I just want confirmation. It is in accordance with the practice direction by the Vice Chancellor, I think last year or the year before. Very well. That's all I had on that, and no orders required about any of that, I think. All right.
No orders required there, Your Honour. We will do the needful and keep the registry in the loop.
Yeah.
Carrying on with the practicalities of the hearing, given Your Honour will be hearing this from Scotland, the registry have indicated that we will be starting at 12 noon in Dubai, which is 9 AM in Scotland. Before proceeding, I should just confirm that that's convenient to Your Honour to start at 9 o'clock in UK.
Yeah, I'm happy with that.
We then go to the end of the day.
I see someone suggested I only sit 4 hours.
Well, I wonder whether Your Honour would be pleased with that suggestion, but that was a suggestion which had come from the registry. I was worried that was not going to give us enough time, and I think Mr. Lovett is also worried that was not going to give us enough time. Yeah. And I'm afraid I was going to invite Your Honour to sit until 6 o'clock Dubai time, which is 3 o'clock UK.
Yeah.
The only practical point, and again, this certainly is above my pay grade, is that may have an impact on the registry staff, and I just wonder whether Your Honour wanted to make appropriate inquiries behind the scenes. But that was the only thought that crossed my mind.
Who is conducting? Who is the case progression officer today?
Yes, Justice, I'm here. My name is Said.
Who is that?
Said.
Said. I think the sitting from 12 Dubai time till 6 Dubai time is commonly done in trials of this sort. Is that right?
Yes, we have no issues about that.
No issues on that. That's very helpful. Thank you very much.
Sure.
So we'll proceed on that basis. The only point I would make is you suggest 2.5 hours, an hour for lunch, and then another 2.5 hours.
Yes.
I'd prefer to lengthen the morning to make it, say, 3 hours in the morning with possibly a 10-minute break halfway through that. Maybe 45 minutes for lunch. And what we could do is make it to 9 to 12:15. So I'm talking UK time, 9 to 12:15, with a quarter of an hour break sometime in the middle of that. Lunch until 1, so it's only 45 minutes for lunch, if that doesn't inconvenience people. And then the afternoon session from 1 till 3. Say for all those are UK time, add 3 hours for Emirates time. Does that suit parties? It's slightly shorter lunch, but I find a lengthy session in the morning is quite tiring without some sort of break.
I mean, the transcribers, and we will undoubtedly need transcribers in a case like this, will appreciate the 15-minute break in the middle of the morning. So that makes sense.
They probably like a 5-minute break every now and again anyway. So we'll do our best. But if we can aim for those timings as a guideline rather than a fixed thing, we'll try and get 5 hours hearing time in every day.
Thank you, Madam.
Super. That's very helpful, Your Honour. And I don't know whether Your Honour turned it up in sorry, Your Honour, I spoke over you.
Do we need an order for this? Say, do we need to incorporate the hearing time within an order of the court? well,
we could follow up, my lord. I think we'll follow up with the registry to see what if they do require. But I mean, for my part, I'm happy not to have it incorporated in an order.
yeah, well, I'll go along with whatever the registry say on that. Yeah, sorry, you're going to add something.
All I was going to say is Your Honour may or may not have seen it, but I had prepared a short trial timetable. It hasn't been agreed by my friend Mr. Lovett, although we discussed it in broad outlines. I don't think it's too far away. But if Your Honour wanted to see what the trial is likely to look like, it's at page 512 of the bundle.
Yeah.
We've allowed for short oral openings by each side, and they probably do need to be quite pithy given the amount of evidence we need to get through. And we've allowed the last day, the Friday, to be closings from both sides orally, with about half a day each for oral closing. So your Honour's got about 3.5 days of evidence, I think, and there's quite a lot to squeeze into those 3.5 days.
If it would help you, I don't. And my experience of these things is that the evidence spills into the final day, with the best will in the world. And but what I don't want to do is then have a rushed full oral closing on each side with only half a day between you. Now, sometimes what works quite well is to have a very short, allow the evidence to spill slightly, then have a short closing each side, no more than, say, an hour, 3/4 of an hour, to sort of headline points, followed by a written closing, which needn't repeat everything, but can flesh out some of what's been said before. It's sometimes useful to have an oral closing immediately after the evidence to focus one's attention on what really matters, and then written closing submissions thereafter, not to the extent of 50 or 70 pages, but no more than about 15 pages, with footnotes if necessary, tying in references and so on, just really to give me the picture. And does that strike you as a sensible way of proceeding, or do you prefer to do a full day of oral closing submissions?
Can I take it the other way around, which is I think both parties were encouraging Your Honour to have written closings, and so I think we would very much take up Your Honour's suggestion on that. As to whether we spend a full day in closing or half a day, it may just be we're driven by what the timetable looks like, and it may well be that that's something we should decide as we get closer to the hearing. But for my part, I would have no problem with the evidence spilling into day 5 and then having an hour or so in closing on the Friday afternoon. But I defer to Mr. Lovett.
Mr. Lovett, are you happy with that?
That works. That works for the defendant, my lord. Yes.
Very well. I think proceed on the basis we'll keep our eye on how it's going. But if we proceed on the basis that some sort of oral submission will be made at the end, but not a full closure, it will be followed by written submissions within a short period afterwards. And I think what we'll do, although you suggested the period of someone suggested 9th August, we can adjust that and see as we go along, and at the end of the oral hearing, we can fix a date for exchange of written submissions. Sorry, will you excuse me? Yeah. Sorry, virtual hearings, one forgets to turn one's phone off.
Your Honour, we've all been guilty of that, so that's where we are. Your Honour, the next point is one of interpreters. Your Honour will have seen that all of the witnesses, both factual and expert, have given their evidence in English. Some of them are native English speakers, some of them have English as their second language. The standard of the English is good throughout. One of my witnesses, Mr. Rashad, who is the CFO, he is Egyptian. His English is good, but when he gets to complicated points, he can become a little bit stuck. And we suggest that perhaps we have an interpreter on standby. So if he's taking a question from Mr. Lovett, finds it difficult to articulate what he wants to say in English, somebody can come to his rescue and interpret from Arabic to English. But I don't want to sort of make that the standard, because it will slow the trial down quite dramatically. But I thought it might be helpful to have an interpreter there if there were some questions which he was struggling with to articulate his position in English, and wanted to try and do that in his native language. But I'm in your honour's hands on that.
I think I understand from the email that Mr. Lovett's side are content with that. Is that right, Mr. Lovett?
Yes, indeed, my lord. Yep, very happy with that.
Yep. Again, do we find out from the registry whether we need an order to that effect? If so, we can make one.
I suspect we will, and we may also have to. We'll obviously have to swear the interpreter in as needs be, but that's something we can do. And Mr. Lovett and I can liaise on the identity of the interpreter and the mechanics for that.
Yeah. Okay. What I'm going to suggest is, at the end of this pre-trial review, you liaise with the case progression officer and the registry to formalise what the orders we've made.
Yes, Justice. It would be best if the parties could send us an email with all of this, so we can put it in an order if needed.
Yeah, thank you, Stade.
Sure.
We're very happy to do that, Your Honour.
Right with you.
Only two more points, Your Honour. The penultimate point is dress. Given that we're virtual, can I invite you to direct the route?
We haven't worn robes in any virtual hearing, as far as I'm aware.
Well, I'm very pleased to hear that. So, Dubai in August in a suit is uncomfortable enough. In a robe, it's particularly uncomfortable.
I'm afraid I'm probably going to insist on jackets, since you all have air conditioning and I don't.
I'm sure jackets will not be a problem, but that is not a problem. My last point is experts. The question of what is known as hot tubbing has been raised. Our position on the claimant's side is that standard sequential evidence would make most sense for both the quantum and the Q80 law expert. Mr. Lovett's email suggests that on the quantum expert, he's happy to start with sequential evidence, but may see some advantage in hot tubbing particular issues. I don't have a huge amount to say about that. I'm really in Your Honour's hands. If Your Honour thinks that the hot tubbing would be helpful, then I'm happy to go with it. My own view is that sometimes hot tubbing makes it more difficult rather than easier. But again, I'm in your hands as to how we do it. I think that we're both agreed that Q80 law should be done sequentially. But again, I'm not quite clear that when Mr. Lovett agrees with that.
Yeah. Mr. Lovett, I've seen your email, which is quantum. You think should?
It's quantum, my lord, principally.
Yeah.
We prefer to call it witness conferencing. I'll leave hot tubbing for arbitration.
It's used in court nowadays, isn't it? This question?
Well, I'm not sure. Witness conferencing for us is the way forward. But I think if the court will find it useful, I think it's just worthwhile having the experts on standby. If there are some issues which my lord would find it useful to hear them simultaneously, as it were. But if we don't need it, then we can stand them down.
I think that sounds sensible. We will make an order for conferencing or hot tubbing. I'm not sure, actually. My other concern is a practical one of whether it works on screens where you've already got documents, and having a split screen with the witnesses and therefore seeing no one else, whether it works effectively. But let's keep it as an option by having the experts on remaining on standby during the other experts' evidence, so that we can cut across to doing it on a particular issue if necessary.
And does Your Honour want that direction in relation to both quantum and Q80 law, or just in relation to quantum?
I think it's been suggested with Q80 law. Is that right?
Correct. I think just quantum on our side.
Just on quantum.
Yes.
Yeah. That's all you have to raise, I think, on your.
On my side, it is. I just want to make sure that Mr. Lovett didn't have anything else, and I know Your Lordship may have some other points.
Yes, I mean, again, just to lay down a marker, we've just in terms of the use of time and the allocation of time, we haven't shared this between us yet, but we have a proposed sort of timetable for each day of the hearing.
Yeah.
My suggestion would be we kind of default to the chess clock rule, so that provided each party has an equal amount of time, we can allocate that time in a way that we think is best in terms of witnesses, openings, and so on. Our opening, for example, we may want to allocate a bit more time because of the complexities of some of the issues and a bit of scene setting at the start. So we may want to spend a bit more time than Mr. Lyons, for example. But my suggestion would be that we allocate time equally, and we can take that offline if my lord is happy with that approach.
I think it's easy to do in this case where we've got the same number of witnesses on similar topics. And I suppose an equal time sharing chess clock approach probably works satisfactorily. It doesn't always work when one side has all the witnesses and so on. But are you happy with that, Mr. Lyons?
I have no objection. If Mr. Lovett wants to go long in his opening, so long as that does not affect my time in cross-examination, then I'm content.
Yeah. Who keeps control of the clock?
We will come to an arrangement between us, my lord. We have clock watchers.
Can you try and have an indicative timetable drawn up before the start? It's not something I'm going to make parties adhere to the minute, but it just gives me an idea of what's going to happen. So if we can revise the indicative timetable to reflect the chess clock approach on the basis of equal time, then that would be helpful. I'm assuming the witnesses will not be taken in chief, except maybe for one or two questions arising out of what's happened before.
I was hoping that the witness statements would stand, so yes.
Yeah, very well. There's one or 2 points. We've covered most of them, actually. Yes, what about the change of names of the parties? There was some talk about the possibility of amendment. Has it happened?
It has happened, so that the parties' names, I think is now reflected in the action heading. But let me just. Okay.
Maybe I was looking at an old document.
I mean, if there is an issue, that's the kind of thing I can deal with your lordship on the first day in the housekeeping. That's the kind of issue which.
No, I don't imagine there's any issue between the two of you. It's simply making sure you have the right for the hearing and for any judgment that follows. Yes, it may well be that they've been changed by amendment at some stage. Okay. No, we've covered actually the various points I had noted down. So I've got nothing else. So if either of you have anything, now's the time. Otherwise, we can conclude this hearing and meet again on the 31st July. Nothing else?
Nothing more from me, Your Honour. I'm grateful for all your assistance, so thank you.
Nothing from our side, my lord. Thank you.
No. Well, thank you both very much for your help and a cooperative spirit approaching the litigation. So let's hope it lasts. Thank you very much, and that concludes.
We'll try.